días. Es un honor para todos nosotros tener aquí el Escuela de Derecho, y el ministro Ulises Schmill. De verdad que es un lujo tener a estas dos personas entre nosotros. Stanley Paulson estudió Derecho en la Universidad de Harvard en 1972 y Filosofía en la Universidad de Minnesota en 1964. Es maestro por la Universidad de Wisconsin-Madison. Fue profesor de la cátedra William Gardner Hammond de Filosofía hasta junio de 2011 en la Universidad de Washington en San Luis, y en 2003 fue galardonado con el Premio de Investigación Humboldt y ha recibido doctorados honorarios tanto de la Universidad de Kiel como de la Universidad de Uppsala en 2004. El objetivo principal de las investigaciones del profesor Paulson está centrado en la teoría y filosofía europeas del derecho, con un énfasis especial en la obra de Hans Kelsen. Ha publicado cerca de 200 artículos y comentarios en inglés y en alemán, y pues sin más los dejo con el profesor Stanley Paulson. De verdad que pues un honor, glad to have you here, profesor. Perdón, ministro, le dejo la palabra al ministro Ulises Schmill. Una disculpa.
Es un gusto y un honor estar aquí frente a ustedes presentando la figura del profesor Stanley Paulson. Tienen ustedes frente a un gran teórico del derecho y al mejor conocedor de la obra de Kelsen, yo creo que en el mundo entero. Como ya lo dijo el profesor Rodrigo Díez Gargari, Stanley Paulson nació en Fairus Falls, Minnesota, el viernes 16 de mayo de 1941, por lo que tiene 71 años, 11 meses. En su fecha de nacimiento, Alemania realizó el último ataque aéreo a Gran Bretaña durante la Segunda Guerra Mundial. Es 5 años más joven que el que habla, pero su carrera académica es verdaderamente gigantesca comparada con la mía. Ustedes lo verán, quizás eso manifieste el tipo de cultura académico de nuestros dos países, México y Estados Unidos. Sin embargo, a los dos nos une un interés fundamental. Hemos estudiado intensamente la teoría del derecho de la Escuela de Viena, creada por el más grande jurista del siglo XX, según palabras de Roscoe Palmer. Me refiero evidentemente a Hans Kelsen. Stanley Paulson se graduó en filosofía en la Universidad de Wisconsin-Madison y cursó sus estudios de jurisprudencia en Harvard, obteniendo el grado en dicha universidad. Le han sido otorgados los siguientes grados de doctor: de la Facultad de Derecho de Uppsala, el 23 de enero de 2004, de la Facultad de Derecho de la Universidad de Kiel, Alemania, el 14 de julio de 2004. Fue recipiendario del Alexander von Humboldt Foundation Research Prize para los académicos en el estudio de las humanidades. Pronunció el discurso de apertura académica en una sesión de la Cámara Alta del Parlamento Federal de Austria en honor a Kelsen en su cumpleaños 125. Ha recibido muchas distinciones y nombramientos como investigador, que no voy a mencionar, pues por su número me llevaría mucho tiempo y estamos ansiosos de escuchar sus sabias palabras. Ha sido un autor muy prolífico. Ha escrito varios libros y recopilaciones publicadas por editoriales tan prestigiosas como la Oxford University Press y la Ciencia Verlag, donde ha dado a conocer textos de Kelsen y de los autores de su escuela que eran propiamente inconseguibles. Ha publicado tanto en alemán como en inglés más de 180 ensayos y artículos y ha llegado a conformar la imagen más adecuada del pensamiento de Kelsen. Reduciendo mis manifestaciones verbales a un tema concreto como es la jurisprudencia y la filosofía del derecho, quiero dejar constancia del cambio observable del ambiente cultural sobre la enseñanza del derecho desde la época en que estudié en la Facultad de Derecho y la que ahora impera en México. En la década de los 60 del siglo pasado, la Facultad de Derecho de la UNAM estaba en manos de algunos juristas con ideología radicalmente naturalista. Y como toda persona absolutista, ejercían su autoridad y las funciones administrativas que se les había encomendado de manera tiránica y, perdonen ustedes, arbitraria. Con ello quiero decir que no permitían el desarrollo y exposición de teorías y doctrinas que difirieran de las que ellos y su camarilla aceptaban y enseñaban. Claro está que con semejantes juristas la doctrina de Hans Kelsen era violentamente repudiada y pretendían criticarla y refutarla, incluso sin haber leído las obras del jurista vienés ya traducidas al español. Me refiero a la Teoría General del Estado de 1925, traducida genialmente por el profesor español Luis Legal da Cambra, y la Teoría Pura del Derecho de 1934, traducida por Jorge G. Tejerina. Recuerdo que en los cursos de introducción al estudio del derecho y de filosofía del derecho, si se mencionaba a Kelsen, era para afirmar que su doctrina había sido refutada desde antes de que fuera formulada y que era una teoría formalista, alejada de la vida real palpitante y por tanto totalmente falsa y hueca. Este era el reproche más comúnmente formulado y era considerado como una refutación insuperable. Como era una teoría formalista, lógica pero vacía, repetían el dictum de Schmill y Heller de que era una teoría del derecho y del Estado sin derecho y sin Estado. Solo había un profesor que en su curso de filosofía del derecho enseñaba la teoría de la escuela vienesa de Kelsen. Me refiero al profesor Guillermo Héctor Rodríguez, a que los maestros naturalistas lo nombraban diciendo que era el Papa Negro. Gran polemista, enseñaba la doctrina de Kelsen de una manera peculiar, muy intrigante. Era neocantiano afiliado a la escuela de Marburgo y quería sintetizar en una teoría unitaria las tesis de Hermann Goel, Rudolf Stammler y Hans Kelsen. En alguna medida incompatibles, según pienso ahora, especialmente con la teoría de Stammler. Pero lo que decía era brillante y muy intrigante. Como él, sus alumnos éramos belicosos y concitábamos la enemistad de todos los profesores. Por tanto, existiendo este ambiente de cultura jurídica excluyente, quiero manifestar a ustedes un fenómeno teórico que es posible observar a últimas fechas. Primeramente, las tesis y teorías de Kelsen han sufrido una serie de malas interpretaciones. Ay, perdón, ustedes. ¿Quién sabe quién soy? ¿Quién sabe quién soy? Malas interpretaciones y ataques desde todos los ángulos posibles, salvo las exposiciones de Joseph L. Kunz y William Ebenstein sobre la teoría pura del derecho. Las tesis de Paulson son reconstrucciones fidedignas y respetuosas del pensamiento del gran jurista vienés. Y esta es una labor necesaria para refutar las interpretaciones, incluso algunas de mala fe, de muchos autores, y con ello sentar las bases de algunas críticas que pueden llegar a hacerse con el objeto de depurar su pensamiento. El propio Kelsen dijo en el año de 1934, cuando publicó por vez primera un librito que lleva el título La teoría pura del derecho, introducción a los problemas de la ciencia jurídica, que la pueden conseguir claramente en español, que ha sido traducida al inglés por Stanley Paulson y su esposa Bonnie Nichevsky de Paulson, y ahora traducida por Gregorio Robles y Félix F. Sánchez, en la editorial Trota, expresó Kelsen lo siguiente: a fin de poder combatirla a la teoría pura del derecho, es preciso que no se reconozca su verdadera naturaleza. Tan es así esto, que los argumentos que se esgrimen no propiamente contra la teoría pura, sino contra el espejismo adaptado a las necesidades propias del adversario, se neutralizan unos a otros y hacen así que la réplica casi sea superflua. Unos sostienen con desprecio que se trata de una teoría que carece totalmente de contenido, que es un juego vacío de conceptos vacos. Otros advierten que debido a su tendencia subversiva representa un serio peligro para el Estado y para el derecho. Una de las objeciones más frecuentes es que se mantiene alejada por completo de la política y por lo tanto de la vida palpitante, por lo que viene a ser algo carente de valor científico. Con no menos frecuencia se oye que la teoría pura del derecho no está en condiciones de cumplir con su exigencia metódica básica, por ser solo expresión de una determinada posición en materia de valores políticos. Pero hay que preguntarse, ¿cuáles son entonces los valores que defiende? Los fascistas la declaran partidario del liberalismo democrático. Los demócratas liberales o socialistas la tienen por una avanzadilla del fascismo. Desde el punto de vista de los comunistas, se la descalifica como una ideología propia del estatismo capitalista. Desde la vertiente del capitalismo nacionalista se la tilda de craso bolchevismo o de anarquismo camuflado. Su espíritu, aseguran algunos, tiene un vínculo de parentesco con la escolástica católica. Otros creen encontrar en ella los signos características de la doctrina protestante del derecho y del Estado. Y tampoco faltan los que quisieran estigmatizarla de atea. En suma, no hay corriente política de la que la teoría pura del derecho no haya sido objeto de sospecha. Pero justamente esto demuestra su pureza, mucho mejor de lo que por sí misma podría ser. Termino la cita. Dicho lo anterior, el fenómeno que es observable es un renacimiento, no en naciones de habla inglesa, con la excepción de mi querido amigo Carlos Ponzo, sino en teorías de juristas de nacionalidad italiana, austriaca, española, argentina, colombiana, mexicana, que se están ocupando con toda seriedad y responsabilidad académica de exponer y analizar las tesis de Kelsen. El péndulo teórico se está desplazando en sentido contrario por una razón. Todo jurista que aborde con seriedad su labor se podrá percatar que la teoría de Kelsen toca y analiza sistemáticamente los problemas que todo jurista tiene que enfrentar. Stanley Paulson es el filósofo y jurista más sobresaliente en la actualidad en el estudio y comentario de las obras de Kelsen. Oigamos sus tesis de análisis. Muchas gracias.
Thank you, Ulises. I'd like to begin by inviting attention to the fact that this is Ulises Schmill Week, and we are celebrating Ulises here at your institution. We're celebrating him at his institution, the town, and we're celebrating him at the Mexican Supreme Court. And I am not only pleased, but indeed honored to be a part of this celebration. And I'd like to take this opportunity to thank my colleagues at the Free Schools as well for their hospitality, for the roles that they played in making it possible for my wife and me to come to Mexico City. As I mentioned at the ETOM yesterday, I'm happy to say it again, we're very happy to be here, my wife and I, and we're having a wonderful time, and we find the hospitality of our Mexican hosts and friends extraordinary. I've made one omission in the paper with an eye to saving just a bit of time in the English language version from pages 5 to 7, and I'll invite attention to that when we reach that point, and in the Spanish version of the text from the bottom of page 5 to the top of page 8. I'm told that the Spanish version of the text is available online for those of you who want to have it. The title of my paper is Empowerment, Liability, and the pure theory of law, I might anticipate the theme in one respect. In a certain respect, this paper counts as a kind of thought experiment. Kelsen talks as though he had been influenced by those in the Margaret School. And he was prepared to refer to Herman Cohen, the head of the Margaret School, at any number of points, but it's my opinion that he did not really understand the Margaret philosophers all that well. And the thought experiment is this: what would Hans Kelsen's theory have looked like if he had, in fact, followed the Margaret School in a significant way? The paper consists of 5 sections, and the first section has your friend Stanley Paulson talking about 2 dilemmas, and you'll reach these dilemmas in the course of the first section. Hans Kelsen occupied himself with issues in legal philosophy over a period of more than 60 years. And the central concepts in his pure theory of law, basic norm, imputation, normativity, purity, and the like, are well known. Still, Kelsen's ultimate aim in legal philosophy has never emerged with much clarity, a point to which I'll return briefly at the very end of the paper. 2 diametrically opposed approaches to Kelsen's legal philosophy, one stemming from Joseph Raz at Oxford, the other from Robert Walter for many, many years in Vienna, illustrate the lack of consensus on the pure theory of law. Raz begins by contrasting Hart's position with Kelsen's. Hart is a proponent, Raz tells us, of social normativity, understanding, and I quote, the normativity of the law and the obligation to obey it as distinct notions, end of quote. An altogether different understanding, Raz continues, is evident in the work of those who recognize, and I quote again, only the concept of justified normativity, end of quote. Among them, so Raz, Hans Kelsen. As Raz writes, and I quote now from Raz's paper, to judge the law as normative is to judge it to be just and to grant that it ought to be obeyed. The concepts of the normativity of the law and of the obligation to obey it are analytically tied together. Kelsen therefore regards the law as valid, that is normative, only if one ought to obey it. Raz sees the paradox in attributing justified normativity to Kelsen, a thesis that places Kelsen far closer to natural law theory than to anything found in legal positivism. Indeed, Raz invites special attention to the paradox, writing that although, I quote again, Kelsen rejects natural law theories, he consistently uses the natural law concept of normativity, the concept of justified normativity, end of quote. Walter's interpretation of normativity in Kelsen's legal theory reduces the concept of normativity to matters of fact. In the pure theory of law, Walter writes, legal systems are to be interpreted, and I quote here from Walter, as if they were normative, end of quote. And he has underlined, written in italics in his text, the conjunction, as if. And this idea stems from Hans Weininger, whom Kelsen in fact follows in his very late period, that is after 1960. Walter, however, understands Kelsen generally in terms of Weininger's as-if doctrine, and not simply with respect to Kelsen's late period. These 2 approaches to the pure theory of law, Raz's and Walter's, are both possible. Both writers offer interpretations of Kelsen's legal theory, but both interpretations represent extreme departures from Kelsen's 2-sided purity postulate found at the very core of his theory. The postulate says that the pure theory of law is to be distinguished, on the one hand, from all value-laden theories, be they moral, political, ideological, and on the other hand, from all fact-based theories, that is, from all forms of naturalism and psychologism. But Rouse invokes, and I quote his line, the natural law concept of normativity, end of the quote, as the underlying notion in Kilson's concept of normativity. And Walter, in appealing to Weidinger's as-if doctrine as an interpretation of Kilson on normativity, is wedded to a fact-based interpretation of pure theory of law. The first of two dilemmas is captured by bringing together these two interpretations, Rawls's representing elements of natural law theory as an interpretation of Kilson, and Walter's representing fact-based legal positivism as an interpretation of Kilson. This first dilemma is Kilson's own dilemma, and it takes as its point of departure his two-sided purity postulate. It says, in effect, looking to these two types of theory, a pox on both your houses. Neither natural law theory nor fact-based legal positivism is, so Kilson would have us believe, defensible. Coupled with the dictum tertium mandator, which some understand as demarcating the tradition in legal philosophy, Kilson's purity postulate dooms every appeal to the tradition, made up of natural law theory on the one hand, fact-based legal positivism on the other. Kilson submits, however, that there is, after all, an escape from the dilemma, namely a third way, based on Kant's transcendental philosophy as expounded in his Kant's First Critique. Kant's transcendental philosophy, Kilson writes, and I quote here, is eminently qualified to provide the foundation for a positivistic legal and political theory, end of quote. And, as important as it is obvious, Kilson's transcendental philosophy in the First Critique appeals neither to morality nor to the facts. So far, so good. Kilson believes that he has escaped the dilemma faced by those who remain in the grip of the tradition. But this strategy of Kilson's leads to a second dilemma, which takes the form of the critic's rejoinder to Kilson. Here the traditional legal theories, natural law theory and fact-based legal positivism, together represent one horn of the dilemma, and Kilson's adaptation of Kant's transcendental legal philosophy represents the other horn. The problem, quite simply, is that no Kantian transcendental argument, even if it should prove to be sound in the context of Kant's own theory, will pass muster when applied in one or another of the standing disciplines, here legal science. The transcendental argument presupposes that no alternative approach to the issue at hand exists. In the standing disciplines, however, there will always be theories that count as alternatives to a transcendental argument. Or more precisely, the proponent of the transcendental argument is not in a position to rule out such alternatives. And I've set out one picture of what the problem Kilson faces might look like in the appendix to the paper with this scheme in which various possibilities are depicted. Kilson, in a word, faces a dead end with all three types of theory. Natural law theory and fact-based legal positivism are indefensible, he assures us, and his own appeal to Kant's transcendental argument proves to be indefensible too. How to proceed from here? Otto Julius Merkel, the most gifted of Kilson's colleagues, with the most profound knowledge of Kilson's legal philosophy among all those in the Vienna School of Legal Theory, wrote that Kant was Kilson's spiritual father. To follow Merkel here, without running afoul of the unworkable Kantian transcendental argument as it is applied in legal science, we might turn to the fin de siècle neo-Kantians. they departed from Kant on, among other things, this very issue, the transcendental argument. In the course of what amounts to a veritable transformation of Kant's philosophy, as we know it from the first critique, the neo-Kantians resorted to Kantian regulative principles, which we will have occasion to talk about. And Kelsen, I'm arguing here, in what counts for some purposes as a thought experiment, Kelsen, I'm arguing here, is best understood as following their lead. To argue along these lines requires some fairly elaborate stage setting. Specifically, I provide in section 2 a sketch of the Margaret neo-Kantian's departure from the Kant of the transcendental analytic in the first critique. I'm going to omit a bit of that text, but I think we'll have enough of it in place so that you can get an idea of what's going on. And then I return in section 3 to Kant and to Kelsen, in particular to Kant's regulative principles in the first critique, his common ground with the Marburg neo-Kantians, and to Kelsen's basic norm, understood now as a regulative principle. And then shifting gears rather dramatically, I invite attention in section 4 to Kelsen's doctrines of empowerment and liability, a favorite theme of my good friend and colleague, Ulises Schmill and myself. And finally, in a brief closing section, I bring together the basic norm qua regulative principle drawn from section 3, and the doctrines of empowerment and liability drawn from section 4. And my central thesis is that the basic norm, understood in the way I'm suggesting, demands the systematization of the law to the greatest extent possible. This systematization aims at recasting legal norms in the modalities of empowerment and liability, an enterprise reflecting, other things equal, the work of the Marburg neo-Kantians. Now it's at this point, page 5 in the English text, and in the Spanish text further down on page 5, and you'll see, of course, at the beginning of section 2, I'm going to omit a good chunk of that section up to the end of the first paragraph on page 7 in the English language text, and up to the end of the carryover paragraph at the very top of page 8 in the Spanish text, the end of the carryover paragraph that is concluded at the top of page 8. So I am in my text, the English language text, at the middle of page 7. And what I want to talk about in what remains of section 2 is the work of Ernst Cassirer, a second generation Marburg neo-Kantian. And Cassirer rejects the Kantian approach in the first critique and offers something quite different. And this approach of Cassirer's will lead us directly then to Kant himself on regulative principles. But we start with Cassirer because it was the Marburg neo-Kantians who, in effect, popularized this notion at the turn of the century, 100 years ago. Cassirer was an unusually outspoken proponent for the transformation of Kelsen's, of the Kantian transcendental philosophy. And in his treatise of 1910, Substance and Function, Cassirer, following Hermann Cohen, rejects the notion of sensibility as an independent receptive faculty. The notion of matter, stemming in Kant's philosophy from sensibility, and the notion of form, stemming in Kant's philosophy from the categories of the understanding, are indissolubly correlated. So Cassirer. And Cassirer then goes on to argue for the necessity in comparing competing hypotheses of an ultimate standard, which he understands in terms of, and I quote, universal elements of form that persist through every change in the particular material content of of experience, end of quote. Cassirer calls these elements the ultimate logical invariance of experience, and the goal, he says, is to provide a complete inventory of them. Even if, and this is important, even if the goal cannot be achieved. Why not? The goal is correctly understood here as an ideal, and we can approximate an ideal, but an ideal by its very nature resists full realization. And that's the idea in the quote that follows here. Cassirer writes, and I quote, "It may be that this goal is not perfectly achieved at any stage of knowledge. The goal nevertheless remains as a demand, prescribing a fixed direction to the continuous unfolding and evolution of the systems of experience themselves." End of quote. Now that, I would be the first to agree, as we say at home, is a mouthful and taken out of context, a bit difficult to get a handle on. But the quote invites attention to two distinguishing characteristics of regulative principles. First, it is recognized that the goal is not achievable, that the ideal, in virtue of being an ideal, cannot be realized. Second, the demand, however, remains continuously to try to achieve the goal, to approximate the ideal. And now in section 3, I'll turn to Kant on regulative principles, and we'll be able to develop the idea of regulative principles in a bit greater detail, even if, to be sure, much in Kant is frightfully difficult. Regulative principles stem from Kant. In the lengthy transcendental dialectic of Kant's first critique, these principles are regulative in two different senses. In the first sense, Kant understands the metaphysical ideas of God, freedom, and immortality as regulative ideas. He means that we may act as if the belief in God, freedom, and immortality were true, but that to attempt to demonstrate the truth of such beliefs would be a mistake. Why so? The purported demonstration would represent an illegitimate use of reason, illegitimate because by its very nature it goes beyond the limits of possible experience. Regulative principles, you'll be pleased to know, in this first sense, are not our concern here. In his appendix to the Transcendental Dialectic, Kant depicts regulative principles in a second sense. Earlier, in the first critique, Kant distinguishes three cognitive powers or faculties. All cognition begins with sensibility, proceeds from there to understanding, and ends with reason. Corresponding to sensibility are the forms of sensibility. Corresponding to the understanding are the categories of the understanding. And finally, corresponding to reason are the ideas of reason. As I noted, the ideas of reason, the regulative ideas, play a heuristic role in the transcendental dialectic. We can proceed as though these beliefs were cogent, but there is no possibility of demonstrating that they are. Alongside the illegitimate use of reason, a topic that Kant pursues over literally hundreds of pages in his first critique, alongside this illegitimate use of reason, his reply really to the tradition in philosophy, there is a legitimate use of reason. And Kant invites attention to the legitimate use of reason in the appendix to his great treatise. Here we encounter regulative principles in the second sense. And the definitive passage reads as follows, as always with Kant, difficult, turgid, but we have to try our best to make sense of it. And so I quote this lengthy passage from Kant. If we consider in their entire range the cognitions acquired by the understanding, we find that what is peculiar to reason, and it stands vis-a-vis these cognitions, is that it prescribes and seeks to bring about the systematization of cognition or knowledge. That is, to exhibit the interconnection of cognition based on a single principle. This unity of reason always presupposes an idea of the form of a whole of cognition, a whole that precedes the determinate cognition of the parts and that contains the conditions for determining a priori, that is, apart from experience, the position of each part and its relation to the other parts. Accordingly, this idea postulates complete unity of the cognition acquired by the understanding, whereby this cognition becomes not a mere contingent aggregate, but a system interconnected in accordance with necessary laws. End of quote. Here Kant introduces the regulative principle of systematicity, what we're going to employ as a reading of Kelsen's basic norm. His reference here in the first critique, Kant's reference in the first critique to the systematization of cognition or knowledge, marks the initial appearance and the controlling example of a regulative principle in this second sense. With the phrase from the long quotation I gave you, the idea of the form of a whole of cognition, Kant gives expression to systematicity, to the unity sought by reason. This is the task of bringing the parts of a whole together in a unity. Reason in lending order to cognition goes well beyond the understanding, whose role is limited to the application of categories to sensibility. The task of systematization, Kant says, must be undertaken lest our cognitions remain disconnected, or, with Kant's wonderful expression, a mere rhapsody, rather than a system of significance both for scientific inquiry and for the formation of beliefs generally. This task is left to reason, which has us, as Kant puts it, interrogating nature. My proposal in this lecture is to conceive of Kelsen's basic norm as a regulative principle to ascribe to the basic norm a systematizing function. In other words, to construe the basic norm as a reflection of Kant's regulative principle in this second sense. I recognize that this proposal is unorthodox. Normally, the function of the basic norm is understood as a grounding function, and Kelsen speaks of a grounding function in the second edition of Pure Theory of Law. An orthodox reading, however, is part and parcel of the problem I laid out in section 1, namely that the grounding function of the basic norm presupposes a sound transcendental argument, and no Kantian transcendental argument applied in the standing disciplines, here legal science, of course, is sound. Thus, following Adolf Julius Merkel's maxim, I am resorting to a Kantian alternative, if you will. An alternative that preserves something of the Kantian dimension of Kelsen's pure theory of law without running up against a transcendental argument that is unworkable in this context. One possible objection to an interpretation of Kelsen's basic norm in terms of a regulative function can be anticipated right at the outset. As Cassirer points out, the goal sought by pursuing the dictates of a regulative principle cannot, by its very nature qua ideal, be fully realized. But, so the objection goes, the leitmotifs of Kelsen's legal philosophy are not ideals, they are doctrines. That is, the normativity of the law, however it is to be understood in the end, is not an ideal. Rather, the law is normative. Membership as the prominent criterion of legal validity is not an ideal. Rather, the legal rule is valid, only if it belongs to an efficacious legal system. The answer to this objection is straightforward. The objection would count only if the basic norm qua regulative principle were directed to such doctrines as these. The basic norm, however, is directed elsewhere, namely to the quest for systematicity in legal science. Textual support for an interpretation of the basic norm in these terms is found in Kelson's wonderful little monograph of 1928, The Philosophical Foundations of Natural Law Theory and Legal Positivism. There he submits that the basic norm underwrites the quest for systematicity. And I quote from this monograph of 1928, Kelson speaking, "With the help of the basic norm, the legal material created by bylaws, ordinances, enactments, and the like must lend itself to an interpretation as a meaningful whole, that is, as altogether reasonable." End of quote. Legal material, with the help of the basic norm, Kelson's line, is to be given a systematic interpretation as a meaningful whole. Kelson pursues this further with greater emphasis on the role of the basic norm as regulative. Another quote from the monograph of 1928, "If the system of positive law norms, which is constructed on the edifice of the basic norm, is supposed to be a meaningful whole, an intelligible construct, a possible object of cognition or knowledge, and this must be presupposed from the standpoint of legal science, which aims to comprehend its object, and in this very connection resorts to the hypothesis of the basic norm, then the basic norm must offer the guarantee. Therefore," end of quote. Save for these passages, there is scant textual support in Kelson's writings for the interpretation of the basic norm as a regulative principle. Kelson himself is wedded, after all, to the cant of the transcendental analytic. But it is the cant of the appendix to the transcendental dialectic that is the key source in the work of the neo-Kantians. Since the attribution to Kelson of a basic norm qua regulative principle is expressly a part of a reconstruction of his philosophy in genuinely neo-Kantian terms, the reconstruction calls only for the caveat that its value will be determined by its explanatory power. Now I'd like to shift gears and talk about Kelson's doctrines of empowerment and liability. That is, we're going to depart from the talk about the basic norm altogether and look at two of Kelson's central doctrines, and then we'll come back in the short concluding section and bring these two notions together. The basic norm, interpreted as a regulative principle on the one hand, and my reading, shared perhaps in part by my good friend Ulises Schmill, my reading of empowerment and liability. Empowerment as a modality in Kelson's legal theory has received little attention in the literature. A wonderful exception to this rule is the work of Ulises Schmill. No less for that, empowerment and empowering norms proved to be fundamental. As early as the Hauptprobleme, the massive Habilitationsschrift of 1911, available, as some of you know, in Spanish, in the translation, I think, going back to 1947, Kelson poses the question, and I quote here an important line, of the ideal linguistic form of the legal norm, end of quote. Die ideale Sprachform des Rechtssatzes. His question in this first grade book. What is the ideal linguistic form of the legal norm? From the beginning, Kelson treated the hypothetically formulated sanction norm addressed to the legal official as the primary norm. By contrast, the command imposed on the legal subject is merely a secondary norm, which is, Kelson says, and this line too is important, which is the secondary norm fully superfluous, for it says to the subject nothing different from what the norms of the first line say. End of quote. The key question, not addressed by Kelson in the early work, is this: what is the modality of the hypothetically formulated sanction norm addressed to the legal official. In the early work, Kelson gives the impression that the official is being commanded to impose the sanction. Not until a lengthy paper of the late 1930s in response to George Sell's theory of public international law does Kelson offer his first systematic answer to this question. What is the modality of the hypothetically formulated sanction law? An empowering norm? A norm of obligation? Kelson writes, and I quote, "The legal obligation of an individual to behave in a certain way is recognized as given only if, in the event of the opposite behavior, another individual is empowered by the legal system to impose the sanction on the first individual." End of quote. By itself, this passage does not establish the priority of empowerment, but an additional, very important point bears on the matter. The empowering norm found in this passage is correctly identified as Kelson's primary norm, the hypothetically formulated sanction norm. The legal obligation of the individual, Kelson's phrase from this quotation, is the secondary norm. From the beginning, Kelson regards the secondary norm as superfluous, dispensable. The language I quoted from the great work of 1911, Hauptprobleme, is repeated verbatim in the treatise of 1945, General Theory of Law and State. That is the doctrine that Kelson was wedded to for a very long period of time. These lines, coupling the new development in Kelson's reply to Sell, empowerment, with the familiar Kelsenian doctrine that the secondary norm is superfluous, open the door to Kelson's mature view. Empowerment represents the ideal linguistic form of the legal norm, and legal norms in their reconstructed form are empowerments. Kelson develops the view further in the 1945 treatise, General Theory of Law and State, and in the second edition of the Pure Theory of Law. The development that emerges clearly in General Theory, the 1945 treatise, is Kelson's new reading of the ought, the German sollen, in the primary norm. As already noted, Kelson in the early work appears to be using the ought to give expression to an obligation, the command addressed to the legal official. In General Theory, the 1945 treatise, Kelson defends, however, a different view. He contends, albeit less than clearly, that the ought need not coincide with the concept of legal obligation. Rather, the ought in the primary norm serves as a placeholder, as akin to a variable expression, indicating that under certain conditions, here's the most basic reading of the variable, under certain conditions, a sanction can be imposed. That is to say, an official is empowered to impose a sanction. What in the case where there is also an obligation to impose the sanction? Kelson replies, and now I'm quoting from the 1945 treatise, under the present definition of legal obligation, the legal norm that obligates the subject to refrain from the delict by attaching a sanction thereto does not stipulate any legal obligation of executing the sanction or applying the norm itself. The judge can be legally obligated to execute the sanction in the sense in which the subject is obligated to refrain from the delict, to obey the legal norm, only if there is a further norm that attaches a further sanction to the non-execution of the first sanction. End of quote. Kelson insists that no regress is implied here. Alf Ross had brought this criticism to bear on Kelson's doctrine. But Kelson insists there is no regress here. That is, in a system of positive law, there will always be a highest level in the hierarchical ordering of the legal system, and at this highest level, only the empowerment to impose a sanction is possible, but the presence of an obligation to impose a sanction would presuppose a still higher level in the hierarchy. exactly what is ruled out by hypothesis that we're talking about. Perhaps not. These details of Kelson's empowerment doctrine are not clear in general theory, the 1945 treatise. But Kelson pursues the doctrine further, in particular in the second edition of the Pure Theory of Law, 1960, where he defends the doctrine expressly in the language of empowerment. I quote from the 1960 work, "If a delete specified by a certain legal system is committed, then a sanction specified by that legal system ought to be imposed, ought to be imposed." Then after a semicolon he goes on, "Here the term ought covers both the case in which the official is simply empowered to impose the sanction and the case in which he is commanded to do so." End of quote. When is the modality of empowerment called for, and when the command? Kelson answers clearly, and I quote again from the second edition of the Pure Theory of Law, "The imposition of a sanction is commanded, has the content of the legal obligation, if its omission is made the condition for a sanction. Where this is not the case, the official can only be taken to be empowered to impose the sanction, not commanded." End of quote. Where an official's failure to impose the sanction, the omission is itself understood as the condition for a sanction. The expression condition here is shorthand for the antecedent of the comparative, hypothetically formulated norm empowering a higher official to impose a sanction. To be sure, in the second edition of the Pure Theory of Law and elsewhere, Kelson has a good deal to say, as we all know, about obligation, permission, and the like, the familiar deontic categories. But in chapter 4 of the treatise on legal statics, Kelson is working for the most part within the framework of the reconstructed legal norm, whose operative modality is empowerment. Summary thus far, having posed in the Hauptprobleme the question of the ideal linguistic form of the legal norm, Kelson arrives ultimately at a defense of empowerment. The ideal linguistic form of the legal norm is the hypothetically formulated norm empowering an official to impose a sanction under certain conditions. The ought in Kelson's work, beginning in the 1940s, is a placeholder akin to a variable expression, as I mentioned, and Kelson has no independent doctrine of obligation in his reconstruction of the legal norm, much less a doctrine, as Ross would have us believe, that lies at the very core of his theory. Rather, obligation is a derivative notion constructed from pairings of empowering norms then on adjacent levels within the hierarchical scheme, the legal system. Still to be discussed in this section, albeit very briefly, and then I come to the short closing section. Still to be discussed is Kelson's understanding of the correlative relation, that of liability. The correlative relation that holds between empowerment and liability is clear. It is a party A is liable to the exercise of power by B with respect to a matter X if party B has power vis-a-vis A with respect to X. By the same token, if A is immune to the exercise of power by B with respect to X, then B has no power vis-a-vis A with respect to X. So far, no surprises. What is interesting, and perhaps even surprising to those who have not looked at Kelson on empowerment and liability, is that liability too turns up as a concept developed by Kelson, albeit obliquely. Here the key is Kelson's notion of peripheral imputation. Peripheral imputation links material facts, Tatbestände. As Kelson writes in the Allgemeine Staatslehre, a work of 1925, and I quote, "Peripheral imputation always leads from one material fact to nothing other than another material fact." End of quote. Two questions arise. First, what exactly would Kelson have us understand by material facts? And second, how is peripheral imputation linking material facts to be formulated? And this, as you'll see, is going to take us to his doctrine of liability. Kelsen answers the first question in terms of legal condition and legal consequence, more precisely in terms of the state of affairs counting as the legal condition in a particular instance, and in Hofeldian parlance, the legal position that emerges as the legal consequence. This seems to be an odd fit, for a legal consequence does not obviously count as an instance of a material fact. Rather, in a hypothetically formulated legal norm, material fact falling within the scope of the antecedent clause of the norm triggers the legal consequence, establishing in Kelsen's doctrine the legal position of liability that counts as the legal consequence. And liability is not understood in the law as a material fact. Still, in introducing peripheral imputation, Kelsen brings together material facts, thus understood. He writes, and I quote, this is the first edition of the pure theory of law, that if the mode of linking material facts is causality in the one case, it is imputation in the other, end of quote. And here you have the ordering principles at work, imputation and causality. And I think Kelsen wants to make the parallel as close as possible, with an eye to lending credence to his claim that legal science is indeed a bona fide science and not nonsense. He uses legal condition and legal consequence alongside cause and effect as the respective relata of these very ordering principles, imputation and causality. That is, he understands their respective relata as species of the genus material fact. The second question addresses the formulation of peripheral imputation. Kelsen speaks of peripheral imputation, and I quote, as the particular lawfulness, the autonomy, Eigengesetzlichkeit of the law, end of quote. What does he mean? Autonomy speaks to the nomological character of the law. It is therefore reasonable to assume that peripheral imputation will lend itself to a formulation that reflects the nomological character of the law. The formulation that emerges is, if you will, a subjectless rendering of peripheral imputation. That is to say, a formulation that does not include an ascription of liability to the legal subject. This formulation might read, if an act of a certain type, namely a delict, takes place, that act is treated as liability ascribing. And I'll return to this peculiar notion of liability ascribing in a moment. This formulation captures the import of peripheral imputation, and it does so in two respects. First, it reflects the link between the two material facts. Second, the link confined here to the act and to the liability imputed, so to speak, to the act, is a necessary link. In this way, the nomological character of the law, its autonomy, its Eigengesetzlichkeit, if you will, is underscored. As Kelsen writes in an enormously important text for my present purposes, stemming from the preface to the second printing of the Hauptprobleme, if there is the necessity of an absolute must, for the law of nature links cause and effect, so there is the equally rigorous ought when the law of normativity sets out the synthesis of conditioning and conditioned material facts. In the sphere of the law, or in legal reality, delict is linked to punishment with the same necessity as in the sphere of nature, or in natural reality, cause is linked to effect. End of quote. This is close to being correct as a statement of Kelsen's position, although one wrinkle has to be ironed out. Kelsen is not claiming a necessary link between the delict and the actual imposition of punishment, for, as we all know, and as Kelsen makes perfectly clear elsewhere, and I quote, in the system of nature, punishment may fail to materialize for one reason or another. End of quote. It is not punishment, but criminal liability, and by the same token, civil liability that figures in the necessary nomological or law-like link. In the most general terms, liability serves in this formulation as the second relatum, the second material fact. The relation of liability to the act to which it is imputed is a necessary relation. By contrast, the actual imposition of punishment in the criminal law, the actual execution of judgment in the civil law, is, of course, a contingent matter. Now back very briefly to this notion of liability ascribing. Where a legal proceeding in fact takes place, then the liability ascribing character of the act is implemented. That is, liability is now ascribed to an individual. And the correlative empowerment to impose a sanction then comes into play. And the result is the familiar pair of correlatives, empowerment and liability, and they serve in Kelson's legal theory as the basic modalities of the law. So I thank you very much for your patience. We are at last at section 5, a very brief concluding section. I bring now together the basic norm and these basic modalities, empowerment and liability. I am interpreting Kelson's basic norm as a regulative principle, thereby bringing it into line with a major thrust of the modern neo-Kantians. The basic norm serves then to dictate the systematization of the law. My thesis here is that an effort completely to recast the norms of the Kelsenian legal system in the modalities of empowerment and liability, and of course their sister modalities, immunity and lack of power, represents a program of systematization, an ideal. The ideal is sharply to be distinguished from the doctrinal point that obligation in Kelson's pure theory of law is a derivative concept. There is empowerment. Another doctrinal point is primary and fundamental. If my argument on Kelson's behalf is correct, these doctrinal points are the case, just as the validity of legal norms is the case. The normativity of the law is the case, and so on. Going beyond the doctrinal points, which are not addressed by the basic norm or regulative principle, there is the goal of systematization understood as an ideal. In closing, my very last paragraph, I return to Kelson's ultimate aim in legal philosophy, an issue I hinted at the beginning of my talk. Kelson is quite clearly not striving to resolve the classical problem of the justification of our obligation to obey the law. As we would put it at home, he has other fish to fry. He is striving to provide a firm foundation for legal science. It is right and proper, I believe, to think of Kelson as a philosopher of science. Legal science, of course. I thank you very much.
Ustedes pueden ver, el doctor Paulson es un teórico, un filósofo del derecho de talla mundial, reconocido por los grandes, porque es uno de ellos, y de ellos muy destacado, particularmente en la corriente metodológico que enseñamos. Pero lo dijo muy bien, esta es la semana de Ulises Schmill. Quisiera hacer una muy breve referencia a por qué estamos viviendo la semana de Ulises Schmill. Esta es una cátedra que se organiza por el ITAM, por la Suprema Corte de Justicia y por la Escuela Libre de Derecho, dentro del contexto de un esfuerzo prolongadísimo, que serán probablemente 5 años de trabajo conjunto siempre han estado presentes en la vida del derecho militar, bajo el impulso, la visión y el trabajo incansable de Rodolfo Vázquez, que no puede dejar de mencionarse. Empezó este esfuerzo conjunto hace cerca de 25 años con el seminario García Magistral, con una participación, un debate álgido, verdaderamente memorable, entre el doctor Ulises Schmill y Eugenio Ulises, uno de los grandes filósofos del derecho argentinos. Un debate fuerte, muy fuerte. El doctor Ulises Schmill, en esa época, sin la memoria no falla, era presidente de la Suprema Corte todavía. Entonces, pues tenía también un cariz teórico institucional de manera simultánea. Y se han venido sumando eventos. Tenemos la cátedra Garzón Valdés, la cátedra Atena Ramírez, y ahora, para nuestra fortuna, para la fortuna de esta escuela, que agradece la aceptación del doctor Schmill, la cátedra Ulises Schmill. No podía fundarse esta cátedra de mejor manera que con la participación del doctor Paulson. Yo pensaba que el mejor conocedor y experto que es en el mundo era el doctor Schmill, pero el doctor Schmill dice que el mejor es el doctor Paulson. Así es que les invito a que se queden con la duda. El doctor Schmill es una persona que vale mucho la pena tener la oportunidad de leer y sobre todo, ustedes ya saben y han escuchado de una importantísima trayectoria como diplomático, embajador en Alemania, en Austria, en Hungría, como juez, una larga carrera que no voy a mencionar, basta con que sepan que fue presidente de la Suprema Corte. Y al mismo tiempo, toda la vida como académico, como artista, como amante de la literatura, he escrito sobre literatura y derecho, un conocedor de la psicología. Tengo la impresión, porque yo no sé nada de eso, soy conocedor de la física. Una cultura amplísima, mezclada con un saber vivir, saber amar a su mujer, querer a su familia, ser un extraordinario amigo, querer a su país, preocuparse por él, cultivar amistades y enriquecerlas a través de vida académica a lo largo del mundo. Entonces, tener al doctor Schmill entre nosotros es un verdadero lujo, una gran oportunidad que esperamos se repita muchísimas veces. Gracias por su presencia, gracias al doctor Gómez, que como siempre nos acompaña e impulsa las actividades de filosofía y derecho, y le da algunas clases al profesor de quinto A, que buena falta le hace, a Rodrigo Díez, y sobre todo al doctor Paulson, acompañarnos con sus conferencias. Gracias.